what are some of the expectations that aren't always met, and then what to look for in a closing. These are some general questions that I know that will help you in your next car wash closing.
Closing usually happens in the office of an escrow agent or an attorney with a title company, and the closing also takes place to make sure that all the documents are prepared correctly, signed correctly, and the closing agent is given final instructions on how to record documentation, how funds are to be delivered both from any lenders, borrowers, and then back again to the seller, the person that is selling the property.
So when do you become involved? Once the contract is signed by the buyers and sellers?
That's typically when the closing agent becomes involved, is when the contract is signed. Contract is executed by both the parties, delivered to the title company or the closing agent, who then acts as an independent third party. We are here to basically be the middleman. We don't represent the buyer, we don't represent the seller. We are the escrow agent, so we remain neutral throughout the transaction. We are the party that is entrusted with holding earnest money, any and all documentation associated with the transaction, so that one party doesn't have an upper hand over the other.
So what have you seen some of the challenges in your line of work? With, say, for instance, a difficult buyer or a difficult seller?
I think most of the challenge comes with not having information up front, not being educated as to the type of property you're purchasing, the type of transaction that you're handling, and what all details need to be brought into play with respect to how you document a real estate transaction.
Say, for instance, in a commercial transaction, a lot of times you are looking at the zoning. And I know you don't have anything to do with the zoning, but have you ever run across a real estate transaction that you were working on a closing and all of a sudden they had a zoning problem and the deal went south, or what have you seen there?
Well, we've had transactions where the zoning did not meet satisfactions of the person purchasing the property. One of the things that you might want to note is that that could be a contractual event where the contract would fall apart. If the zoning is not within the satisfaction of what the buyer is looking for, then the contract terms, if it's contained in the contract, that could be a term of where the buyer would be able to terminate the contract without any consequences to the buyer. He would not lose his earnest money, things like that. Other events that we've seen would be where the buyer would still want the piece of property, but you're now in a position of having to go in front of planning boards and things like that to get zoning changed or zoning approved. So it would create possible delay.
You know, Kelly, what are some of the entities? Like, for instance, a deal we're working on is a gentleman is doing a 1031 exchange, and he bought it from he's buying it, or excuse me, he's selling it, and it's sole proprietor, and then that 1031 has to change over to another entity. And how do you guys play in a 1031?
For 1031 purposes, our role does not change. We still act as an independent, neutral third party. We simply bring in another part to the puzzle then. 1031 is a tax deferral, and it's authorized by the Internal Revenue Code. So what most people do when they are utilizing a 1031 exchange is they will actually hire a company that does nothing but specialize in 1031 exchange transactions. And at that point in time, we take the transaction from being the buyer and the seller to being the buyer, the seller, and the 1031 exchange. However, that 1031 exchange works into it. Does the 1031 exchange work for the seller? Is it an outgoing 1031 exchange, or is it an incoming 1031 exchange, where the buyer is using money from a sale of property to purchase additional property, replacement property, to take advantage of the 1031. So basically a 1031 entity, a 1031 company, is no more than an additional party to the transaction.
Now you follow all the documentation. Make sure it's all brought in. And is there anything that you've ever seen that's kind of thrown everybody off a little bit, or?
One of the things that you need to be cautious about is the type of entity that you have formed in order to either take title to the property, or the type of entity that actually owns the property has vested title in themselves. So if you are working through a trust, who is the trustee? You need to know who the trustee is. If you're working through a corporation, who are the authorized parties that are allowed to execute documentation on behalf of the corporation? Where are your corporate minutes? Where are your corporate articles? Where are your corporate resolutions? Those are things that you're going to need to have on hand and be available to provide to the title company, to a lender, to possibly seller or buyer, to make sure that you are working with the proper parties and working with a organization.
So you have to have the documentation there, like you said, corporate minutes or a trust. Do you have to have the whole trust there, that document?
Not necessarily the entire trust agreement. If there has been an attorney involved who prepared a memorandum of trust, we oftentimes will review the memorandum of trust to see if it satisfies the requirements of the title company for authorization to act on behalf of the trust. If those things are contained within the memorandum of trust, then we'll oftentimes accept a memorandum of trust.
Now, I've noticed that when we sit down at a closing table, the buyer and seller have to present their driver's license.
Correct.
What is the reason for that? And is that in every case that you do a closing?
That is more for a notarization purpose, to satisfy state law with respect to notary publics, because oftentimes documents, in order to be recorded, have to be notarized. The notary is wanting to make sure that the person who is signing the document, the person who is appearing in front of them to sign the document, is actually who they say they are. Therefore, they have to produce some form of identity.
I tell you, one time personally, I was in a closing that we didn't fund. And here I was expecting to get a big check that day, and they were saying, well, sorry, the funds aren't available right now. I mean, tell us a little bit about funding and what are some of the restrictions.
That's a good point, because closing and funding are two different beasts. Closing is where the documentation is signed and we make sure that we have the right papers in our file, the right instruments, so that we can get everything to the lender to evidence that the note's been signed if the lender's involved. Deed of trust is there to secure the collateral. The funding is actually where the money changes hands. Oftentimes funding will not occur unless the lender has received their original package back, their original note, their original any kind of guarantees that the lender may have required, any documentation that the lender requires the borrower to execute at closing. Additionally, title companies, escrow agents are often restricted by state law in the type of funds that we can receive. You can't come to closing and write a personal check for $1 million and expect the title company to be able to fund your transaction. Title companies are bound by good funds laws, where we have to have certified funds in our account before we will ever fund a transaction. So the restraints that Capital Title places upon a closing and a funding would be, we will accept up to $1,500 in personal funds. Other than that, it has to be certified funds. Certified funds we would consider to be anything presented to us with respect to a cashier's check. Certified funds, wire transfers work as well. So we have to make sure that the funds are in our account before we can actually start dispersing funds after the closing takes place.
So you have this big, beautiful table here. You have the buyers on one side, the sellers on the other, and I'm assuming sometimes you'll have attorneys there.
Correct.
And brokers, and then everybody kind of pushes paper around. You make sure everybody's signed properly.
Correct.
And then what happens after everything's signed?
That's when the title company manipulates all the packages, makes sure that the seller's documents stay with the seller's side of the transaction. The buyer's documents gets distributed to the buyer as well as to their lender if there's a lender involved. The title company also, or the escrow agent, will handle the recordation of the documents if they have been so instructed. So we take care of and are responsible for making sure that liens are perfected by recording them properly in the county where the property is located. We also make sure that the lender gets their loan documents back intact, so any and all notes, guarantees, additional documentation with respect to insurance and things like that get back to the lender so that they can document that their file is complete on their end. And at that point in time, the title company will then wait until transaction is funded, meaning all funds have been delivered to the title company. We have a instruction from all parties that as soon as funds are delivered, then we can distribute the funds. At that point in time, the title company then records the documentation, disperses all the funds, and makes sure that all the parties have copies of their documentation, either in a closing folder or closing binder. As soon as recordation is done, the title company then moves into the next stage, which is issuance of a title insurance policy if one was purchased through the closing. And that should be the final step in what we do as the title company, is issue your final title policy, which ensures the transaction.